Ladies and gentlemen, welcome to tonight's meeting of the Committee of Adjustment. This is a meeting to consider applications for minor variance and consents that is held under authority of the Planning Act of Ontario. Please keep in mind the intent of our process this evening is to review the proposal that's before us, listen to all the evidence, and then make a decision. This process is not intended to be used to resolve any concerns or disputes that may exist between the town, individuals, or organizations. If a request for deferral is made this evening, the committee grants such a request. The committee, after consultation with our Secretary-Treasurer, will set a new hearing date. No further notice will be provided unless there are changes to the application. In order to conduct an effective and efficient hearing, we've adopted the following process. The owner or authorized agent will be given the opportunity, if so desired, to briefly explain to us the basis of the application and answer any questions that arise out of the hearing process. A maximum of 5 minutes will be provided for this presentation. You need to state your full name and address for the record. Any materials that's submitted to the committee for viewing will remain the property of this committee, and any submissions beyond the 5 minutes will be at discretion of this committee. All persons who are attending the hearing who wish to either support or oppose an application must also state their full name and address for the record, and you'll be provided 5 minutes to make your presentation. All remarks and questions are to be directed to the chair of the committee, and again, any submissions beyond the 5 minutes will be at discretion of this committee. If there are several speakers that share the same view, please select a spokesperson to present the group's combined opinion. We want to hear all the views. However, covering the same points doesn't help us to arrive at a decision quicker. The owner or agent will then be provided further 5 minutes to respond to comments made by any interested parties and answer any questions from the committee members. If the owner or agent has any concerns found in the staff report, particularly with any of the proposed conditions, this will be your opportunity to advise us. The matter will then be taken into committee for a decision, and that will mark the end of all discussion from the floor. Once our committee makes an oral decision, any person desiring a copy must file with the Secretary-Treasurer at this meeting a written request for notice of decision. We provided green sheets in the back table, in the back wall, that you can please fill out and leave with us before you depart the hearing this evening. Please note that you must make a written request in order to be included on any list that is used by the Ontario Municipal Board for the giving of any subsequent notice of any appeal. Written notice of our decision will be mailed not later than 10 days for minor variance and 15 days for consent to the applicant, the owner, and or agent, and any other person who filed a written request for such notice. If you do not agree with our decision, you may appeal this to the Ontario Municipal Board. The last date to appeal the decision to the board will be noted on the decision itself. If no appeal is received within the prescribed time frame, the decision of this committee becomes final and binding, and our Secretary-Treasurer will then notify the applicant through subsequent written correspondence. People attending this meeting this evening are to be courteous to and respectful of the members of the committee, town staff, and other people in attendance tonight. Also, tonight's meeting will be live streamed and available for future viewing on the town's live stream page at oakville.ca/live. And we ask that all cellular phones and pagers be switched off or put on vibrate during the course of this meeting. Thank you. There is one regret this evening. Mr. John Hardcastle could not be here. Is there anyone here that has a declaration of any pecuniary interest? Mr. Charlebois, yes.
Yes, thank you, Mr. Chairman. With respect to CAV A138-2017 at 190 Arichat Road, I'm going to declare a conflict there. I happen to know not the applicant, but the applicant is selling that house to a purchaser who is really driving this particular variance. Okay.
Thank you for that. Any others? See none? Okay. Is there anyone here this evening that wishes to either request a deferral or withdraw an application? Okay, there's a good bunch of show of hands. So you can step up, sir, and then we'll just give Ms. Mihalovic here a chance to Yes, go ahead.
Thank you, Mr. Chairman. Through you to the committee, the town would like to request a deferral of application CAVA 132-2017 at 17 Rebecca Street due to insufficient notice. That notice has since been revised and is on the agenda for the next meeting. Getting the nod from the Secretary-Treasurer. So we'd like to move that ahead at the town's request, not the applicant's request, and therefore no fees would be, or additional fees would be required.
Sir, are you here on that one?
I'm here on that one, yes.
Okay. Is there anything you wish to add on that?
No, I just wanted to confirm that we were going to be on the August 8th meeting.
Okay, is there anyone else in the audience that's here for application CAVA 132-2017 at 17 Rebecca Street? Okay, so you're on the agenda for August 8th.
Thank you.
Okay, perfect. Anyone else?
Jason Heater, Hicks Design Studio, deferral for CAV 138-2017 at 190 Airshot Road.
Okay. Mr. Charlebois, I guess, well, you should maybe depart. Just as Mr. Charlebois is departing the room, is anyone here, here for application CAVA 138-2017 at 190 Airchat Road? Okay. Okay, sir. Deferral, nature of your deferral?
We feel we have great resident support for the application in its current state. However, we'd like a bit of time just to make some minor amendments in order to see if we can get planning on side for this one.
Okay. Sir, unless there's anything unique or different to add to it, you had a show of hands. You want to give us your name and address so we could record you for the record? Sure. I know. Just come up, just so we know that, is there anything else you wish to add? Because our committee normally defers.
Opposed, but no, nothing else to add. John Hillis.
Okay. Okay, John Ellis?
Hillis,
John
Hillis.
Okay, members, are you comfortable with the deferral request? Okay, all those in support? So this matter's deferred. We won't fix a date, you'll need another notice. And then there's a deferral fee, and you gotta get your plans in, you know the drill.
I do.
Okay,
Thanks very
awesome,
much.
thank you. Anyone else? Maybe you can ask Mr. Charlebois to come in on your way out. Thank you. All right, we'll start off with application B1703 at 262 King Street West. This is a consent application. We'll deal with it together with application CAVA 48-2017, again at 262 King Street. This is a minor variance and consent. We'll deal with the minor variance or the consent first. Sir, name and address for the record.
Good evening, Mr. Chair, members of the committee. My name is Terry Martino with Grenweiss Architect and Associates, 341 Kerr Street in Oakville.
Okay, just before we ask you for a presentation, let's see if there's a need for one. Anyone here this evening have an interest in application B1703 and minor variance CAVA 48-2017 at 262 King Street? All right, there seems to be a good supply of show of hands, so you should proceed on the presentation, sir. Yeah, somehow it needs to be zoomed in.
Zoomed in. Thank you, Mr. Chair, members of the committee. With respect to the severance application, as noted in the planning comments, the purpose of the consent application is to convey a 20-foot wide westerly portion of the front lot of 262 King Street to the rear lot, Lot E at 262 King Street, for the purpose of maintaining access to the rear lot as well as servicing. The subject site of 262 King Street, presently that configuration, is comprised of two whole lots in a registered plan of subdivision. They are Lot B, which is the northerly lot, and Lot E, which is the southerly lot. As I mentioned, these are two whole lots on Plan 1 of the registered plan subdivision in the town of Oakville. The lot addition is necessary to service and gain access to the lot to the south as a result of the town closing Front Street, which is more commonly known as Dingle Park. And obviously, at that point, Lot E, over a period of time, became landlocked, as they say, or didn't have any more access. In creating the lot addition to the Lot E, it's important to recognize and understand that the Lot B, the front lot, still conforms to the zoning bylaw in every regard. So that is with respect to the minimum frontage of the retained portion on Lot B. The minimum lot area conforms to the zoning bylaw. The Lot B presently has a dwelling on it. Its coverage conforms to the requirements of the zoning bylaw. Its gross floor area, as well as setbacks, all conform to the existing zoning bylaw. From a historical perspective, so these are the subject lots here. This is King Street, this is Dingle Park, this being the lake. This is Lot B that I mentioned, this is Lot E. Again, as staff have pointed out in their comments, in the First Heritage District, there are other, it's hard to see, similar lots in these configurations which have come up over time. This one is 21 Reynolds, 23 Reynolds, and you can see that there's a configuration for servicing and access because this is part of the waterfront trail. There's another one at 25 Trafalgar. In the first and second district, this is a similar way of dealing with these properties. Again, this is a park at the foot of First Street, and this configuration for the purposes of access and servicing was provided. There's another one on 2nd Street in the first and second district where this is the lot here, in which this is the strip that was granted for access, and the lot configuration is similar. Similarly, there's one at the foot of Chartwell as well as Park Street, and you can see the configurations as I've outlined there. So it would be our submission that the retained lot, being B, conforms to the zoning bylaw, which is consistent with the official plan and severance applications, and that the 20-foot access and servicing strip, which is a requirement of Halton Region. Halton Region does not service over easements anymore. They haven't for some time. It's required that you actually own the land for them to service you out to the street. There obviously are no services on Front Street, and so out of necessity for the development of this lot, which was a whole of a lot in registered plan of subdivision, which has development rights, the lot addition becomes necessary. Would you like me to speak to the minor variance with respect to this as well, or would you like to do them together? So the minor variance, and there's a single variance that is required, and that is to meet the minimum frontage as this abuts King Street at a distance as prescribed by the zoning bylaw 7.5 meters back. It would still only be 6.1 meters or 20 feet wide. Therefore, the variances permit this Lot E, which is still 104 by 104, and again, a whole of a lot, to have a lot frontage on King Street now with the reduced frontage of 6.1 meters instead of the 18 that's required. Again, this is a resultant of it used to have frontage on Front Street, and as a result of the 2014 bylaw, the definition of street for frontage purposes was changed to a traveled street as opposed to just a street, whether it was unopened or not. So again, we find ourselves for the minor variance application seeking a variance because the frontage was effectively taken away by the 2014 bylaw.
Okay, any questions? So the lots have not merged for the purposes of Planning Act. They remain separate lots. So the effect of this application is just to provide frontage for the purposes of the definition of the new zoning bylaw. But it's only wide enough that it doesn't trigger variances to Part 1 and to provide just basically a driveway and service access, 6.1 meters.
That is correct, Mr. Chair, yes.
Interesting, okay. Any questions? Okay, sir, if you can have a seat, we'll get those that showed an interest to come up and relay those. Yes, sir. Whoever would like to come down for it, there's no order. Choose amongst yourselves.
I'm George Niblock. My address is 78 Allen Street, and I'm the president of the Lakeside Residents Association. Lakeside, Oakville Lakeside Residents Association. Pardon me? President? Yes. So our concern with, there are some consequences from flipping the frontage from Front Street to King Street. And one has been addressed, I believe, in a condition that's been attached, which is that the border between the front lot and the back lot, once they make the frontage King Street instead of Front Street, that border becomes a side yard for the purposes of the setbacks for any new residents on that property, which kind of throws out of whack the spacing between the intended spacing between the houses, front and back and sideways on either side. So I believe they have submitted a plan to Heritage which shows that they will be 11 meters back from that border line that they'll build. But the request, and I believe there is a condition included, that that be treated as a front yard, so there's 6 meters of setback from that border line to the front, basically like a front yard of that house. Because otherwise they'd be right up close behind them.
The trouble is, we don't have whatever was submitted to the Heritage Committee. We don't have
Okay.
any plans with this minor variance, but effectively, I think what's going to happen is that little small 6.1 meter strip will become your front yard. What fronts on Lake Ontario will become your rear yard, and the side yard is going to be the same, I think. Maybe it's the other way around. So perhaps you can help us with that, because we don't have any plans here.
Through you, Mr. Chairman, as part of the consent report that was
Yes.
submitted, if you will look at Appendix C,
Yes?
we did include the landscape plan, which actually had most of the detail, would also effectively result in a site plan of sorts, but it shows the positioning of that dwelling
Okay, yes,
as
yes.
proposed. I do have other plans and graphics that were provided with the heritage permit if the committee would like to see that in terms of getting a better understanding of what has been already submitted to the Heritage Committee for approval.
So, Mr. Black, have you seen the report, sorry?
Niblock.
Niblock, sorry. My apologies.
Okay.
Have you seen the landscape plan that's referenced in Appendix C of the staff report?
I think I've seen that.
Okay, that's the one where they have the 11.27
Right.
meter setback and the 8 meter setback?
Yes.
Is that what you're referring to?
Well, what I'm referring to is the condition. Can you talk to them about the condition? Oh, I haven't seen this, no.
The condition that staff have requested with respect to the minor variance is to ensure that no building or structure be closer than 6 meters to this property line.
Right,
Under the terms of the zoning bylaw, this would otherwise be deemed as a side lot line.
Right.
So to protect for the spatial separation, which we've referenced in our comments, we've indicated that an appropriate positioning of the dwelling should not be closer than 6
6
meters.
meters.
What this plan indicates and what the Heritage Committee approved was that the building is actually sited some 11 meters from that limit.
Okay. All right, so it's in effect a reverse variance. They were, under the zoning bylaw, they would be allowed to come closer, and you're saying it shouldn't be less than 6 meters, is that right?
Correct.
Okay.
And then the other adverse effect of flipping the frontage from Front
So
Street.
just to close that loop.
Sorry,
you're-
yeah.
You're not satisfied with that?
I'm satisfied with that and the condition that's been
Okay,
included by
good.
the staff.
Yeah, that's helpful,
Yeah,
thank you.
thank you. The other adverse effect is that when you change the frontage from Front Street to King Street, the point at which they measure height allowable height for the building, which is 10.5 meters, I believe, is taken from the center point of King Street, rather than the original intention for this lot, which would have been Front Street. There's, from the siting of this house, there's about a 2-meter rise in elevation up to King Street. And so while the application that I've seen that Heritage approved was only for a 9.7 meter in height, if they submitted a different plan on this lot, they could actually go to 10.5 meters, which when measured from King Street would be 12.5 meters. And so what we were asking is that there be some requirement in order to accommodate this access and so on, that the original intention of the previous bylaw and the usage, the location of that lot on Front Street be maintained somehow by taking that height measurement from somewhere such as their new front yard line or from Front Street or somewhere on that property rather than King Street.
All right, we'll let the agent applicant respond to that. I don't know what it does. We don't have any plans before us.
As I said, it doesn't actually change their plans. It doesn't impact their plans to put that condition in there. It would impact possible future plans if this plan didn't go through and the consent has been approved. At that point, somebody could come forward with another plan that was effectively almost 4 meters taller than the plan that they've submitted this time around. So we're satisfied with the plan, I think, in terms of height on what they've submitted. But what we're talking about is the sort of adverse effects of this switch from frontage on Front Street to frontage on King Street. It means you can build a much taller house. And in a heritage area, that's not a good thing.
Ms. Halovich, you had a response to that? I think you were showing your hand.
Through you, Mr. Chairman, again, I have some material that might be of benefit to the committee in terms of what has been evaluated by a heritage committee and an approved heritage permit, which would indicate the physical height of the structure, albeit 2 meters lower than the established grade at King Street, which Mr. Niblock is referencing, as well as the perspectives that have been provided by the applicant through that heritage process. So I'll post those as well for your consideration.
Right, so you're saying the heritage permit addresses, and that's a permit that's approved by council?
What they've approved is the height that's being requested, which is 9.7. They wouldn't look at what the bylaw then allows
Right, but
some future applicant to
But the
submit.
heritage permit is in relation to these set of plans.
That's right.
And the height for these set of plans is measured as if it was from Front Street.
No.
So, through you, Mr. Chairman, to the committee, when issuing a heritage permit, there is no zoning review that is
Right.
conducted. It is
Correct.
assumed that the applicant has done their work in determining what the zoning requirements would be. So that being said, this particular dwelling, as it was presented to the heritage committee, which is difficult to see, this measurement is about 31 feet, so it's about 9.7 meters in physical height from the base of the building structure here, so the front step, to the tallest point, which is this peak at the roof here. You'll see that the structure then tapers down at the sides. So this was the built form that was approved by the Heritage Committee. When measured from established grade at King Street, the height in of itself would be about 7.75 meters because the grade is about 2 meters higher, whereas the physical height of the building is about 9.71 meters or 77 meters. What Mr. Niblock is suggesting is that by using the established grade at that northerly boundary that we referenced earlier, which is similar to the grade that's been provided here. There would be no impact in affecting the design of this proposal as it relates to the zoning bylaw. There may be an impact if it were taken from Front Street. It is about a meter lower, but if it were measured from that common boundary line that we referenced earlier, the physical height would be fairly identical to the established grade height that would be measured under the zoning bylaw.
That's exactly right.
For also, from a perspective.
So what's the
point of view-
summary of all that?
Yeah. So from a perspective point of view.
Because we're a little bit handcuffed. We haven't seen these plans before. We know that there was an approval and we don't, as far as we're concerned, there is no variances beyond that which has been sought for minimum frontage.
I don't know if they can zoom out a
That's
little
right.
bit in the back there just to show the perspective.
Zoom out, please. They may have left to watch the Blue Jay game. Whatever.
So, Mr. Chairman, the application before you this evening is for the consent and associated minor variance. The applicant, as they will speak to you, is not the applicant that has proposed this development. I'm not sure if those people are actually here this evening. This is the proposed purchaser's plans, and they proceeded with a heritage permit application. The property is still subject to site plan control, as it's within 50 meters of Lake Ontario. So there would be further refinements, possibly through an engineering review, zoning review, et cetera, in terms of the ultimate development plans for this proposal. But these plans would present the committee with an understanding of what has been considered by town staff to date with respect to what is anticipated to happen on this particular parcel, should the consent and minor variance be granted this evening. Staff have only proposed to you the one condition. It's our submissions that the bylaw in this particular area does allow for a 10.5-meter height. It does allow for, the Heritage District does allow for the opportunity for some of the existing heritage buildings to achieve that height through various means, whether it be by additions or whatnot through the heritage review process. The expectation is that the vicinity and area, everything would level out, and in our view and site visits that we've conducted towards the back end of this property, the two properties that are closest to the lake actually taper down as well, and they have a significant walk-up condition. So in summary, everything would be the same. However, staff would not object to a condition similar to what Mr. Niblock is proposing, to measure established grade from that particular common boundary, as it's in our view that it would not negatively impact the plans as they were presented to us, and a house could still be constructed that comply with all of the requirements of the zoning bylaw.
But how would you word that condition?
So in anticipation of that possibility, staff have provided the Secretary Treasurer with language.
Can you read that to us? That the grade, okay, read it to us. That the grade separation,
That the grade elevation for established grade be measured.
hang on, grade. Someone needs to read this back. Be measured. Okay,
At the center point
Mark, you're writing this down, at the center point
of the original
of the original,
northerly
yes,
lot line
right?
of Lot E.
Plan 1,
No, just Lot E.
Plan 1. Okay, thank you for that.
So that would satisfy our concerns.
Okay,
Thank you.
thank you. Any questions? Anyone else wishing to speak to the committee, please? Yes, sir?
Duncan Galloway, 275 King Street.
Mr. Galloway?
Yeah,
And again,
275 King Street.
thank you. Yes, sir?
We'd just like to get assurance that the proposed driveway of 20 feet would not result or not cause the destruction of the trees and there are several very mature trees which, as far as we can see on the plan, look like they're on the route of the driveway. And that would quite severely diminish the key feature of the neighborhood, which is obviously mature trees.
Okay, well, I don't know what kind of assurances we can give you, but we'll have the applicant give us a response to that. We don't have any inventory or to see what the health of the trees are, but usually everyone in Oakville, at least in my experience, strives to keep trees. That's one of the predominant features that sells properties the most.
Yeah.
But we'll ask Mr. Ricci to give us a response.
Okay, but as far as I can see on the
Sorry,
plan, there's trees one mile.
Mr. Martino. I saw the smirk in his face. I know I got it wrong.
Okay.
You two have to stop wearing blue shirts on the same day. Okay, thank you, Mr. Galler. Anyone else wishing to speak to the committee? Okay, Mr. Martino in the blue shirt. Oh, is there someone else? No, this is your chance if you don't hear from you. Oh, trees, okay, so it's, yes, that's what I'm gonna hear right now. Okay, thank you. Okay, Mr. Martino, my apologies.
That's okay. I think there was a memo circulated, Mr. Chair.
Could have been worse.
Thank you, Mr. Chairman. With respect to the comments by Mr. Niblock, staff, we've had some conversation with staff, and we would not object to the variance which was proposed, or
To the
excuse me,
condition.
the condition to the
Okay.
variance on the subject property that was imposed, that the midpoint be taken for between midpoint grade be established at the line separating Lot B and Lot E. I think it's wholly consistent with the fact that if we're using this as more or less the front lot line
Sure.
for Lot E, for the purposes of setback, we would use it for height too. So we
Okay.
have no objection to that as a condition.
Okay, what about the trees?
Just finish.
Oh, sorry.
One. Just for clarification, and it's kind of confusing, we are not the architects for the applicant who is proposing and who made the application to Heritage. If we were, I would have provided you with those drawings so that the committee and the public would have a much better idea. We have no control over that. It's not our project. I am aware of some of the drawings which have been shared with us through staff, but that's about all I know. I think as planning staff have pointed out, this lot being in proximity to the lake is subject to site plan. And as such, I think any of the landscape plan which was presented here by staff, they would have taken into consideration any concerns for the existing trees, which are presently along the western border, their retention and or consistent with the tree bylaws, their removal and replacement in the tree canopy coverages. So I guess as the agent for the application tonight with respect to the severance and of the access strip to provide the access to Lot E, I cannot offer the gentleman any assurances because we're not in control of that. There is no development proposed by this application right now. These are just, it's an access, it's a lot addition to the rear lot. But again, I think it's important to note that any development that would go on through there, and clearly that applicant is carrying forward, has talked, I think, extensively with planning staff. They've been through a heritage application. They provided this landscape plan from Mr. Pettis, I see, would take any of that into consideration with respect to the existing trees and canopy coverage.
Okay, thank you. Any questions? Yes, Mr. Chalowski.
Thank you, Mr. Chair. Question for Ms. Mihailovich. In reading condition 4, is the answer to the resident's question that the applicant's already been approved to cut down a number of trees under the town's tree bylaw?
Through you, Mr. Chairman, to the committee, condition number 4 of the consent, which is found on page 7 of the report that Mr. Chalowski has pointed out. The applicant, he can elaborate for you, proceeded in front of council with the request to remove a municipal tree in order to proceed with this application. And as part of a council resolution in June at a council meeting, it was determined that a financial compensation of $25,000 was appropriate to permit the removal of the municipal tree within the right-of-way. The developer of the lands, again, not the applicant before you today, would be subject to the private tree bylaw and its rules and authorities in assessing all of the trees that are intended to be removed, and appropriate compensation would be required. As mentioned, a site plan application has yet to be submitted. An arborist report will be required to be submitted with that application to understand the existing trees and what is intended to be removed under the private tree bylaw. Through that process, additional plantings and additional compensations may be provided at that time.
Just supplemental to that, numerous times we get staff comments recommending deferral of applications until site plan is sufficiently advanced. Can you explain why staff didn't feel that the site plan should be sufficiently advanced and deal with these issues before this came forward to committee?
Through you, Mr. Chair, to the committee member, one of the items that we did feel was important in order to advance this application was the issue of the municipal tree that was effectively in the middle of the proposed driveway. This application has been on hold for a number of months now to resolve that particular issue, which we felt was hindering the possibility of moving this application forward to be in front of you today. The other matters with respect to the site plan application, we felt were appropriately deferred to that time, given that there weren't very many constraints with respect to the potential development of this property, understanding that the Conservation Authority also has had an interest and have already indicated their limit of development. There did not appear to be any further constraints. So we believe that this application, as it's presented to you today, is sufficient to move forward and allowing the planning processes and other planning applications to evolve as they need to.
Good. I just have a quick question. It's normal to see where there's a lot addition, a condition that says, in this instance, Part 2 become a lot addition to Lot E, Block 24, Plan 1, or well, it does, but it's normally a condition, so there's no prospect of Part 2 becoming a freestanding lot.
Through you, Mr. Chairman, I understand the question. We did not require, for instance, a merger agreement that Part 2 be merged with the land to which it's being added because it is currently under the same ownership. What will happen is the appropriate Planning Act restriction will be provided on the certificate issued by the Secretary Treasurer that no further conveyance of Part 2 would be permitted once the lands have been added to Lot E.
I don't know what the certificate is going to say. We don't get involved, but it's just the possibility that Part 2. I guess you're saying that that's a normal condition in your. Because I think it's.
I believe legal reviewed this and didn't feel it was necessary at this point that it would be covered off when the certificate was issued. That's from our legal department, because they were the ones who would put on a merger agreement and they would move forward with that. But for this application, they felt it wasn't necessary.
Okay. Thank you. Any further questions? See none? Okay, we'll take this back to committee. Who would like to move a recommendation? We'll deal with the consent application B, 1703. Sir, you were offered the opportunity. You chose not to speak to the committee. We don't go back now. We're going to take this into committee. Who would like to move a Yeah, and we heard the evidence on the trees. Well, this is why I asked if you had anything you wish to add, sir. Well, very quickly, because we're taking this matter to committee. Come on down, quick. We'll take this out of, it's a little bit unorthodox after we close the discussion to have people back. Sir, Mr. Martino, don't go too far. We're not covering the same points, right?
Not really. I mean, I'm not
somebody who's conversant.
Name and address for the record?
My name is Michael Niblock.
Michael?
Michael Niblock.
Okay.
And I live in a heritage home, 268 King Street.
Any relation to the other Mr. Niblock?
He is one of my sons.
Different address?
Yes.
Okay.
We live in that particular heritage home that is kitty corner to this particular application. And we find with this variance, we now have somebody's front yard in our backyard. I mean, this gentleman said that these L-shaped plots are in other parts of the city, but they're not desirable type of development. I mean, when you get people parking in an area which fronts onto your back yard. The other thing is that the side yard setbacks seem incredibly small for the size of the building put on that particular plot, although we don't know what's going to be put on that plot. So we've been presented with a situation where we don't know what's going to happen. We've been asked to give our consent to something that would affect us, but we don't know how. So I move that the variance for that doesn't go forward until we can see what they're going to actually put on that lot. I'm particularly concerned about the side yard setback between lot E and F, as this plot is in fact the floodplain for our whole area, and a lot of our water drains away into the lake through this area. There are these sort of issues. I don't know whether the Committee of Adjustment have any comments on this, but it doesn't strike me as particularly desirable to put such a large structure in this location. Thank you.
Okay, thank you. Any questions? Sir, Mr. Martino, anything you wish to add?
Thank you, Mr. Chair. With respect to the gentleman's comments, I guess I would answer that the side yard setbacks are going to be the side yard setbacks, at least the minimum as prescribed by the zoning bylaw. And again, this application, there's no development proposed. Staff has noted, and I've said in my comments, that any development on this property would be subject to, heritage review, obviously zoning review, and a full site plan process. I would just like to add, and I omitted some comments with respect to Mr. Trelawski's comments with respect to the tree. Through numerous and varied and consultation with planning staff about the town tree, an agreement was reached, and a number of the residents, the councillors were involved, and including the Lakeside Ratepayers Association, Mr. Bob Laughlin, who was in favor of the proposal. My client had proposed to plant up to 5 or 6 trees. As it turned out, the agreement ended up being a one-time cash payment to compensate for the removal of the town tree. So there was wide consultation through that process. This application was first made in January, so that there was a number of consultations, again, with staff and with the local residents and ratepayers association.
Okay, thank you. All right, we'll now officially close all discussion from the floor. We'll take this matter to committee. Who would like to do a recommendation on the consent application B-1703? Mr. Charlevoix? Thank you.
Mr. Chairman. There's a lot of material here to consider, and having visited the site, read the staff report, listened to the the presentation here by the applicant as well as some of the concerned neighbors and local ratepayers associations. There's a couple of things. There was a comment made earlier about the creation of flag-shaped lots, and you're quite right. It's not the preference of the town to create these things, but I believe what you heard in the earlier presentation by the applicant was this is the methodology that the town has been using in the past. I know as a committee member here, and I think I kind of heard the same thing, it's a lot easier for us to judge these flag-shaped lots when we're able to see the application that goes along with it. It does make it confusing. However, having said all that, and having taken into account everything that's here, I do find that the creation of this flag-shaped lot makes sense. I'm not going to talk to the building that's being created here at all. I do believe that and I'm sort of talking between the consent and the variance here, and I do believe that the two conditions, one that the town had put forward before with respect to the 6-meter setback from the northerly lot line of Lot E, as well as what was discussed here, which was measuring the height of the building from the center of the northerly lot line of Lot E, makes some sense. And I see no reason why we wouldn't grant this, finding that it meets, it meets the province's request as well as the municipality, and it brings a lot back into being that couldn't exist before. So having said all that, I'm going to put forward that that having considered the matters set out under Section 5124 of the Planning Act, 1990s amended, I believe that this application does conform to the official plan and zoning bylaws, and I recommend that the application be approved, subject to the provision that the applicant must fulfill all the conditions of schedules, I know it's A and just A, I think it is, right?
Just A.
Just A.
And you find that all the tests under 5124 will be met and no subdivision plans required for the purpose of this application?
You can add
Confirm that?
in.
Yes.
Yep.
And reflection on the minutes, or not on the presentations that were made this evening and the written submissions?
I believe I didn't note that taking into account the comments from the municipal, or the residents, as well as the Ratepayers Association.
Okay. Is there a discussion on recommendation? Mr. Tulowski?
Thank you, Mr. Chair. I understand the necessity for this consent. I'm very troubled by the fact that the committee doesn't have any drawings. And I appreciate that something has to come first, but usually we at least get a set of drawings. And where I can't support this tonight is I've heard two relevant, what I believe to be relevant concerns from the neighbors. One about what's happening with those trees on the site, and the other about creating a front yard and a backyard with no details of what's being built there. And with the Planning Act requiring us to take into account and state how we've taken into account the residents' concerns, I'm not sure how I can do that when the answer to both the questions is really that'll come later at site plan. And I just feel I need to see what's being proposed on this property to be able to address the concerns, or in my mind address that, or conclude that the concerns of the residents are being taken into account or are not relevant to the variances. So while I understand and support the overall concept of this, I'm not comfortable supporting it tonight without any drawings being provided to the committee.
Thank you. Any further comments? Just for the record, I find that council has at least on 2 occasions reviewed this application, perhaps not in the same vein as we have under the Port test, but they've done a heritage review which has gone through council. Permit has apparently is available. And there was quite an extensive consultation discussion on the tree permit. The added review that will take place not only during the site plan process, but the site alteration permit, I believe will capture many, if not all, of Mr. Tilowski's comments and concerns. So I'll be supporting the recommendation to approve. Any discussion? Seeing none? Yes.
One question. Should we be bringing in the variance as well? 'Cause
Well, we will in the second motion.
okay, because it does form part of the conditions of the.
Well, it is a condition, and then there's a second recommendation that I'll ask you to consider as part of the variance. So in respect of the consent application, the recommendation is to approve for all the reasons we heard, subject to conditions and Schedule A. All those in support? Those opposed? Mr. Tilowski is opposed. Okay, if you can carry forward with the minor variance application, the concurrent one, CAV 48-2017 at 262 King Street. I guess staff recommended now 2 conditions.
So, Mr. Chairman, taking into account the approval of the consent, also noting again the staff report as well as the comments from the Citizens and the Ratepayers Association, I do find that this particular variance does meet all 4 tests under the Planning Act. I'm going to make a recommendation that it be approved, subject to 2 conditions. The first condition is, as presented in the staff report, that no building or structure be permitted within 6 meters of the original northerly lot line of Lot E. The second condition, I am going to ask the Secretary Treasurer to read again into the record, if she wouldn't mind.
Absolutely. That the grade elevation for established grade be measured at the center point of the original northerly lot line of Lot E,
Block 24, Plan 1.
Block 24, Plan 1.
Okay.
And I see no reason here for us to put in our standard variance, our standard condition about a 2-year development, as there is no proposed development upon this lot.
Well, there is, but not the one that requires the building permit at the moment, but we're just creating a lot by way of this minor variance. Okay, discussion recommendation, subject to those 2 conditions. My only additional thought on that would be that the agent, or at least the plans we have in front of us, all point to the suggestion that the intent of the minor variance that accompanied the consent is to create the lot to make a legal lot with frontage, and with that, the expectation is, as presented to the Heritage Committee, that the building can be sited in a manner that meets all the requirements and regulations of the zoning bylaw. And we have, in effect, provided through your condition, Mr. Charlebois, 2 almost reverse variances, or at least the first one is a reverse variance where we're restricting the side yards in the manner described, or at least the one condition proposed by staff, and the second one is to ensure that the built form height-wise provides for a compatible fit consistent with the plans that were approved by the Heritage Committee. And I'm quite sure if the envelope that's being presented can't meet any other regulations zoning bylaw, there'll be an opportunity either to revise the plan to make it conform or proceed before the Committee of Adjustment, and we'll hear from the residents again, I'm quite sure. But based on creating the lot, which unfortunately was put out of compliance because of some municipal actions, I think this is a wise recommendation with the 2 conditions. So any further discussion on that? See none. The recommendation is to approve subject to those 2 conditions. All those in support? No one opposed? Mr. Tilowski, do you oppose? Yes, okay, Mr. Tilowski opposed. So that application is being approved. All right. So we'll proceed with application CAVA 133-2017 at 1362 Devon Road. Good evening, sir. Name and address for the record.
Good evening, Johnny Regina from 38 Silva Piano Crescent, please.
Thank you, sir. Is there anyone here this evening that has an interest in application CAVA 133-2017 at 1362 Devon Road? Okay, members, I'm in your hands. We have a staff report that has reviewed the application. You've done your site visit, studied the application. Is there any items of clarification, anything you wish to ask the agent? Sir, is there anything you wish to add? Just so everyone that's here tonight knows that our procedural bylaw allows us to dispense of a full public presentation where circumstances warrant, just like yours. So we can proceed to a recommendation on this if there's nothing you wish to add.
I have no further, nothing to
Okay,
add.
thank you. Who would like to move a recommendation? Mr. Telesky?
Thank you, Mr. Chair. I'll move the application be approved as applied for. The variance in front of us provides for a front yard setback that's clearly consistent with the adjacent house. I find that it meets the 4 tests of the Planning Act. I would note that there was no public objection or support for this application. I'd make the approval subject to 2 conditions: that development proceed in general accordance with the drawings provided, and that a permit issue within 2 years.
Thank you, Mr. Telesky. Any discussion recommendation? See none, all those in support? No one opposed, your application being approved.
Thank you.
Okay, application CAV 134-2017 at 3054 Swansea Drive.
Good evening, Tammy and Dave Mooney from 3054 Swansea Drive.
Okay, thank you. Again, we'll see if there's anyone here this evening that has an interest in application CAV 134-2017 at 3054 Swansea Drive. Okay, members, I'm in your hands. Any questions, items of clarification? Anything you wish to add to your application?
No, we do have permission or confirmation from all the neighbors that are backing onto our property that they are fine with.
All right, so you polled and verbally you can tell us, although they haven't signed anything, that they're in support of your application.
Yeah, they signed to confirm that they were in support of it, so we have letters from each one of them.
Okay, thank you. Any questions? Okay, we'll take this matter in committee. Thank you. Do you have the letters here?
Yes, I do.
Oh, sorry. Okay, I thought they were already pre-filed. All right, we'll take those in so we can record them as letters of support. Thank you.
Okay.
All right, in the meanwhile, who would like to move a recommendation? Thank you, Sherry. Ms. McCall.
Mr. Chairman, I'd like to move a recommendation to approve this application as submitted. I believe it is minor in nature and does satisfy the general intent and the purpose of the official plan as well as the zoning bylaw. It's a minor variance requesting the covered portion of the rear yard have a slightly smaller setback. And having said that and received the notes that none of the neighbors have had any objections or mentioned any negative impacts on their abutting properties, I will move a recommendation to approve this application, subject to the condition that planning staff has requested that the proposed covered patio be constructed in general accordance with the plans as submitted, and our general 2-year.
For a building permit.
Yes, thank you.
Okay, discussion recommendation? Seeing none, all those in support? No one opposed, your application being approved.
Thank you.
Thank you.
Okay, application CAVA 135-2017 at 179 Viewbank Crescent. Good evening, sir. Name and address for the record.
Joris Kieran, Kieran Design, 100 Bronte Road, Unit 10 in Oakville.
Okay, thank you.
Agent for the applicant.
Thank you. Again, anyone here this evening that has an interest in application, CAVA 135-2017 at 179 Viewbank Crescent. Okay, members, I'm in your hands. Do you wish a presentation and the items of clarification? You've done your site visit, read the staff report. Sir, is there anything you wish to add?
No.
Okay. Well, we're going to take this matter to committee then. Who would like to move a recommendation? Mr. Tulowski, thank you.
Thank you, Mr. Chair. I'm prepared to move the application be approved as applied for, finding that it meets the 4 tests of the Planning Act. Note there is no resident opposition, and I would also note, Mr. Chair, that despite the fact that this house is larger than the bylaw requires, I find the design to be very sympathetic and masking the fact that the house is larger than the bylaw currently permits. I would make the application, obviously, subject to compliance, general compliance with the drawings provided, and that a permit issue within 2 years.
Thank you for that. Discussion recommendation? See none, all those in support? No one opposed, your application is being approved.
Thank you.
Application CAVA 137-2017 at 2520 West Oak Trails Boulevard.
Good evening, Mr. Chair and members of the committee. My name is Carlos Espinosa. I'm with my wife, the owners of 2520 West Oak Trails Boulevard.
Okay, thank you, sir. So you're doing the platform. Is there anyone here this evening that has an interest in the application CAV 137-2017 at 2520 West Oak Trails Boulevard? Okay. So, sir, if you can give us a quick presentation. There's someone here with a show of hands.
So, so we are requesting a relief of the minor variance for a setback of 5.28 meters instead of the 6 meters that is required by the bylaws. We believe this is minor variance in nature and doesn't have any concern in terms of privacy or any other concerns. And that's also the staff opinion that evaluated this request.
Okay. So you're basically 5.28 meters from the rear yard, and the bylaw requires 6.
Correct.
So it's a 0.72. Okay, just have a seat, don't go too far. We'll ask someone who showed their hands to come forward and explain their concerns.
Evening, Mr. Chairman.
So try to speak to into the microphone or pull it down so we can hear you.
Good evening, Mr. Chairman and members of the Committee of Adjustment. I'm going to read my concerns.
Okay, we
If
do
you
have
don't
your
mind.
letter. Can you tell us where you live first?
Yeah,
And
my
your name?
name is Ranjana Buckley, and me and my husband and my children, we live at 2524 West Oak Trails in Oakville. So we are neighbors of Mr. Carlos.
Yes.
You know, I was just a bit concerned, and as I was saying, that we all are familiar with the saying that a man's home is his castle. So, which is so true. And today I'm here to defend my castle and my family's rights to privacy. We bought this house in the year 2000 for the woodlot and the privacy and beauty it offers. We have no ill will against Mr. Carlos and his family, who are charming young family. Recently, Mr. Carlos Espenza, our neighbor at 2520, started to build a deck in his backyard, which became oversized and has extended 2 feet in his backyard. I wish Mr. Carlos had designed his deck differently and got a permit from the town of Oakville and built it to code. We understand that town codes are here to protect the privacy of the immediate neighbors, especially in houses built so close. This additional 2 feet structure has created concern for me and my family. It has triggered cause for anxiety for our privacy in our own home. The extension has encroached and intruded in our privacy. Anyone standing or sitting on their 2 feet extended deck will be able to look inside our dwelling, including our family room. And now my family's rights to privacy has been affected. So, Mr. Chairman and Committee of Adjustment, I therefore request that please deny this variance. I hope and request the committee to rule in our favor. There's nothing minor about an extra 2 feet of extension, especially when it is a permanent structure and where the houses are built so close, for it will affect and bother our family's rights to live day-to-day living and privacy in their own home, and also for future occupants of this house. by pulling down the 2 feet projection, we may able to preserve some of our privacy in our home. Thank you, Mr. Chairman and committee members, for listening to my concerns.
Thank you. Don't go, we may have a question. So I don't know if you've seen these pictures.
Yeah.
Sir, do you have these pictures? Can you put them on the screen for us? Don't go away, we may have some questions. We're just trying to get the pictures on there so we can get a better perspective on exactly where you are and how this deck relates to your deck. Flip it the other way around. Okay, can you show us now where your house is in relation to the deck? No, you can come up and point to it.
I can't see it properly now. I think our house is on,
So it's got to be one of the two houses there, right? Either that's the picture on the left or the picture on the right. I think you're the picture on the left?
oh yeah, that one, this one, I think. Oh, yeah.
Is that your fence there, or?
Yeah, this is our house. And you can see that because of the extension here,
Can you use a microphone, because we can't pick you up?
sorry. Because of the extension, ahead, it doesn't show it so well, but this kind of, they can look into our home. Because our privacy screen is very small, and their floor is higher than our floor of the deck.
When did you put your deck in? Because the survey we have doesn't show any decks on these properties.
This
And how-
was done about 8 years ago, 8 or 9
Right,
years ago.
because we have the surveys here as part of the original subdivision work, I'd imagine. And none of these properties showed a deck. Even if they had a deck, it must have been a small one. They've seemed to all been replaced over the years.
Yeah, because originally in the year 2000, when we occupied, the builders had given everyone small, tiny decks in 2000.
Right.
And then we built ours in 2006 or 7. I don't recollect exactly. And ours was built to code because we approached the town, and they specifically told us that it has to be the code because the privacy of the neighbors have to be taken into consideration, and therefore there are town codes.
You see how all these, you can't see it from here, but from the survey, it shows that all the lots are a bit staggered. The rear walls are offset by each other by a bit, by a foot or two. So, it creates a little jag and a little jag and a little jag.
Sorry, Mr. Chairman,
Your
I'm
name
her
and
husband.
address, sir?
My name is Vivek Buckley. I'm her husband, and we built our deck.
I'm assuming you're at the same address?
Yes.
Yes.
Okay, thank you.
And we built our deck in 2007, and we have the official permit from
Okay.
the town.
Okay, thank you. Any questions?
Just got one. You mentioned that the deck, I only got to read your objection afterwards. So you mentioned that their deck is higher than yours, and I've heard that a couple of times. How much higher? Can you just give me?
I was just doing a estimate, like if it's like this. We didn't go and measure because
Right.
obviously can't go on there.
No, but is it like 6 inches, a foot, 2 feet?
No, much more.
Okay.
Yeah, it doesn't show here. That's the
No.
thing. I did take photographs and I did send it to Heather McCree, I think.
Yeah. Just
And
your best guess would be what? I'm
Sorry,
not
just-
holding
I
you
don't
to
know,
it.
maybe he might know how much higher they are.
Yeah.
So it's quite high.
A foot, 2
Yeah,
feet?
maybe a foot
Oh,
or
like
so.
that, okay.
And our privacy screen is not that high.
Right.
It's less than 6 feet, because I remember I told the person who was doing it, I said, how come it's so low? And he says, oh, well, we made a mistake.
So your concern is at the end of
Yes.
the applicant's deck, he can actually look around your privacy screen?
Yeah, I mean, I don't know, I can't even, we should have bought the
That's
pictures.
the only concern, and one and only concern is the privacy concern.
Okay. So, so it's not so much that he can look into your yard, it's more that he can look around your
Inside
privacy
of
screen.
a house.
Okay.
And
got it.
that's why it's our concern, because that's our family room, and most of the time we stay there. And they are going to be able to look into our deck anyways because of the height difference. So,
So just on your privacy screen, it looks like it's built on a different foundation. In fact, it looks like that whole thing is a privacy screen / deck that is more than 6 inches or 6 feet from the bottom of the grade. It's quite high from the picture.
no, it may be high, but I'm
See,
comparing
all
to
these
this.
houses are walkout basements, right?
Yeah,
So all the balconies or the decks here come off the kitchen, presumably,
yes,
right?
yeah.
Yeah. I mean, I gotta tell you, I find it hard to believe that someone's gonna build a deck so they can look in your backyard. That's not why
No,
people
that's
build
not the
decks.
intention. You have to understand, if he had done it according to the code, that's what I felt. I don't think town would have permitted him to go that far ahead. That's my concern.
Yeah, and so have you had a chance to review the town's staff planning comments on this application?
No.
Okay, so you've talked to the municipal planner here, Ms. Kay Halovich?
Yes,
Okay, she
I
wrote
did.
the report, or someone with her in her department wrote the report, and they did an assessment on the impacts you indicated,
Yeah.
and you don't agree with them?
No, I didn't read what they had said.
Okay.
I just spoke to, I communicated by email, and she said you can go and talk about your concerns.
No, of course, yes, that's true.
And that's all we are doing, we are expressing our concern.
Okay.
Because I don't know if it's, that's my thing, that if he had built according to the code, then, because we were told that town codes are here to protect the privacy of the immediate neighbors. And I feel because of the 2 feet extension, they can look into, I'm sure his intention was not to do that. But, sometimes when you're building, you just want to build bigger and better. I don't know. So,
Okay, thank you very much.
thank you.
Anyone else wishing to speak to the committee on this application? See that, sir? Back to you.
Mr. Chair, just to address concerns of my neighbors, I have a couple of pictures here. This is a better picture of the look
Right.
from the kitchen. So you can see there is a screen. There's nothing we can see from here. And I also took a picture from.
Sir, if you were to put your finger to approximately where this additional variance for the depth projection will be, where would it be? Because you built it and you know the dimensions. So from the edge of the deck?
Without the variance?
Yeah. Where would it be approximately? Just
Maybe
draw-
around here. Around here. Around 70 centimeters.
So can you just put a line through it so we can see it? Oh, that's not working. There you go. So everything to the back of that meets the bylaw, everything to the front
Yeah.
doesn't meet, more or
Yeah.
less?
Yeah.
Okay, thank you.
Yeah, it's not exact, but yeah.
So where does the screen fence line up with that line that you just showed us? If you were to put another line that shows the screen,
Yeah, we need to do the projection here, actually.
approximately, we're not being accurate here, I just wanna get an assessment of what section of the deck will be protruding that visual plane that we just heard your neighbor describe.
Yeah, so I don't know. So if you stand here and probably in the corner, you will be able to see a corner of their window. I don't know.
Okay. Yeah.
So I have another picture taken from the far end of that structure.
Right, okay.
And you can see
gotcha.
you don't see much.
So where would you project if you were if you were standing at the very, very, very edge of the deck? Approximately what section of this rear elevation would you be able to see?
Well, it's hard to tell.
I know. But you built a deck, or someone built a deck, and they were probably standing there.
Yeah, but it wasn't me. I haven't
Okay.
go there.
Okay, well, never mind. If you can't show us, you can't show us. Anything else you wish to add, sir?
No, that's all I have, and, and our intention is never intrude in our neighbors' privacy.
Okay. Any question? All right, well, we'll give you an opportunity, but we can't go around like this. You know, these discussions should be had before you reach the committee. It's usually helpful to tell your neighbor and your neighbor to tell you. I'm assuming you guys discussed it? Okay, you want to come forward and let us know? Because although we accommodate, but, you know,
I
we have to be
understand. So,
reasonable. People
yeah.
have expectations for a fair hearing.
I had sent pictures to Heather McCree and Kate.
Okay, we do not have pictures.
Oh.
So if you have them on your cell phone or somewhere, please show us.
Sorry,
No.
I received no pictures. Your email said pictures to be sent at a separate email, and I never got any pictures.
Or maybe I sent it to Kate.
No, Kate would send it to me. We didn't receive any pictures.
Can I just go and get, I've got it in the car though.
In the car?
Yeah.
No,
No.
no.
It's just one thing I wanted to comment.
Can you put that picture back, sir, that you know, that picture that we just discussed, view of angle? Yeah, there's a copy there. From your perspective, how much of your rear deck do you think you'll see? The other picture?
The other picture is, yeah.
That's okay, I'll come back.
Which one, this?
Well, that one and the other one as well.
Yeah,
Yeah, that one. So put that up. Put that one up.
This one?
Yeah, put it up.
Okay.
So I'm standing right at the edge of the deck, right
Yeah.
at the corner, the
And-
last 2 feet.
Yeah, this is the way this is. And the
So,
way
okay,
is-
now show me the other picture. And show me where you think that angle takes you.
This way. And we've got all our windows here, the bay windows.
But your railings are 4 feet high or 3 feet high.
No, the way that it has been taken a photograph, it makes a difference, you know, because this angle makes it look very, it doesn't look so.
Right, it's taken from the grade. It's not taken from the top of the deck. We understand.
Yeah, so it's making it look very innocent, but it's quite a bit. This.
Okay, thank you. Okay, we understand. Sir, just to be fair, do you have anything you want to add? Yeah, you got to come up. You got to come up.
So in our opinion, and I believe it's in opinions of the staff, the difference in the setback doesn't make any difference in privacy for the neighbors. So I don't believe it's a major concern.
Okay, thank you. We'll take this matter to committee. Who would like to move a recommendation? Yes, Ms. McCall.
Mr. Chairman, I'd like to move a recommendation to approve this application. I'm satisfied that from what we've seen here and the reports as well as the presentation, there's a minimal 2 feet differential between what the applicant is proposing and what the bylaw requires. While I sympathize with the neighbor, I don't see the negative impact that they are claiming in terms of privacy and overlook here. And I can perhaps offer a very simple and comment to the applicant to put up some privacy screening on that side to mitigate any issues with their neighbor. You don't want anyone looking into your backyard either, and your amenity space either. So perhaps that be something that you would consider and everybody would leave here happy. And I'll leave that up to you. But as far as I'm concerned, the variances that are set before us and the application does meet the 4 tests. and it is appropriate for the development of the site. And I find that the opposition has failed to show those negative impacts of the abutting properties. So I'm moving that we approve this application, subject to the condition that the proposed uncovered platform be constructed in general accordance with the plans dated May 10th, 2017, as submitted. And the approval will expire within 2 years from the date of the decision if the proposed development has not proceeded and/or a building permit not issued.
Thank you. I just have a quick question, sir. Your plans show in the diagram A07, they show a tempered glass.
Yes.
Is that for the side looking to the neighbor that we just discussed?
Which one is exactly that one?
It says Plan A07. This one here. It
Yeah,
shows
that's
6
tempered glass.
millimeter
Yeah,
tempered glass.
that's on both sides, yeah.
It's on both sides?
Yeah.
Is it opaque?
It's clear glass.
Clear glass?
Yeah.
Okay, I think you need to change your recommendation.
But I can change it for a privacy screen.
No,
so-
we're gonna do it as a condition, so it become a full privacy screen
Okay.
rather than a tempered glass.
Okay.
Okay, can you,
And I'll add a condition that the the tempered glass submitted in
that'd be a
in-
full privacy screen instead of a
in the
tempered glass.
drawings,
In drawing
be,
A07.
be a full privacy screen or frosted glass in order to maintain the privacy on either side of the neighbors.
Okay.
Is that
Yeah.
sufficient?
I think we can work with that. Thank you.
Thank you.
Discussion recommendation? Yes, sir.
Mr. Chairman, just taking into account I was questioning this one when I first came in, and so listening to the presentations here, I was actually leaning towards the idea of not supporting this particular application, finding that the reason for the minor variance is to ensure that there's sufficient amenity space in the rear yard and to protect from any negative overlook and privacy impacts. And every situation is different. Every set of houses are different, and we had gotten a presentation here about the proximity of these houses and the way things were set up. And quite frankly, it becomes a very subjective thing in defining privacy. However, based on the recommendation that was put forward by my colleague here in creating the privacy screen, I think this is a great solution to the problem. So with that condition in there, assuming that this goes through, I will be supporting this.
Okay, thank you. Any further discussion? I just wanted to add my comment on the record that I think the incremental increase that's been sought of roughly 0.72, together with the conditions that we just heard, bring it into what I think more in conformity with the zoning bylaw and meets the 4 tests. I'm in agreement with the recommendation and the comments by Mr. Charlebois. So the recommendations to approve subject to those conditions. Yes?
Can I just read out the condition to make sure the applicant is
Yeah,
aware?
that the Plan A07 be modified to show a privacy screen. Is it on both sides or on the one side? That the plans be modified to show a privacy screen on both ends of the deck. Another quarter in sound.
I guess so. Just for clarity on the requested condition, to whose satisfaction would you like that to be assessed?
Satisfaction, Director of Planning.
Okay.
Okay. That's okay, we'll screen, we'll get it all on tape. Okay, the recommendation is to approve subject to those conditions, all those in support? No one opposed, that application is approved. Sir, we'd like you to submit the revised plans as quickly as possible. Yep. Okay, to the director? Okay. Oh, yeah, sorry, to the secretary, and then they'll get it approved by the director?
Perfect. No
Okay,
problem.
thank you. we'll proceed on application CAV 139-2017 at 2430 Woodcrest Drive. All right, we've gone live.
Good evening, Mr. Chair, members of the committee. My name is Melanie Schweitzer. I am the homeowner at 2430 Woodcrest Drive.
If there's a discussion, we can, Kate? If there's a discussion, you can proceed outside quickly or we can hold it down. Yes. Sorry, Ms. Schwarzer, is it?
Schweitzer.
Schweitzer, apologies for the little, okay, go ahead.
Not a problem.
Okay, so
I'm in
we
your
got your
hands,
name and
Mr.
address
Chair.
for the record?
Yeah, 2430 Woodcrest Drive. I'm the
Okay.
homeowner applicant.
Thank you. Okay, so is anyone here this evening that has an interest in this application? Application CAVA 139-2017 at 2430 Woodcrest Drive? Okay, members, I'm in your hands. Would you like a presentation? Do you have any items of clarification? You read the staff report, did your site visit? Is there anything you wish to add to the application?
No, Mr. Chair.
All right, looks like we're going to take this to committee. Who would like to move a recommendation?
Mr.
Yes, sir.
Chair, having visited the site, read the staff report, and I note that there are no comments either in support or opposition from the town. I find that this particular variance does meet the 4 tests on the Planning Act. I'm going to make the recommendation that it be approved, subject to the condition that the proposed in-ground pool be constructed in general accordance with the plans dated June 2nd, 2017 as submitted, and further subject to the condition that this approval will expire 2 years from the date of this decision.
Yeah, there's no building permit, so maybe we'll
Oh, that's
skip
right,
that
too.
one. Yeah.
Well, do you
Okay.
need a building permit
So-
for a swimming pool? No? No?
So substantially in accordance with the plans?
So substantially in accordance with those plans, then. I'll stop there.
Having received no comments from the public and no letters, and
All
you said that?
said all that.
Okay. Discussion recommendation? Seeing none, all those in support of the approval, subject to the condition? Okay. Those opposed? Sherry, are you in agreement? Okay, so it's unanimous. Your application's been approved.
Thank you very much.
Thank you. Application CAVA 140-2017 at 287 Jennings Crescent. Yes, sir, name and address for the record.
Good evening, Mr. Chairman. Joris Kieran, Kieran Design, 100 Bronte Road, Unit 10. I'm the agent for the applicant.
Thank you, Mr. Kieran. Is anyone here this evening that has an interest in application CAVA 140-2017 at 287 at Jennings Crescent? All right, it looks like we're running out of people by attrition here. Is there anything you wish to add to your application? I don't think we need a staff, or we don't need a presentation on this. Members, are you satisfied you don't need a presentation, done your site visit? Okay. Anything you wish to add, sir?
No.
All right, we'll take this matter to committee. Who would like to move a recommendation? Thank you, Mr. Tulowski.
Thank you, Mr. Chair. I'll move the application be approved, finding that it meets the 4 tests of the Planning Act. It's a minor increase in the size of the dwelling, but with a compatible design for the neighborhood. Note that there's no resident opposition. Make that recommendation conditional on development proceeding in general accordance with the drawings provided, and then a permit issue within 2 years.
Thank you, sir. Discussion recommendation? See none, all those in support? No one opposed? The application's been approved.
Thank you.
Thank you, sir. All right, we'll proceed on CAV 147-2017 at 374 Burton Road.
Hi, Rob Kent, 374 Burton Road.
Thank you, Mr. Kent. Again, is there anyone here this evening that has an interest in application CAV 147-2017 at 374 Burton Road? Okay, seeing none. Members, I'm in your hands again. Do you wish a presentation? Anything you wish to add to the application, sir?
No, this was actually already approved, just back here because of a clerical error.
Okay. Right, yes. Thanks for reminding us on that. It was approved.
Only brings the point that it is unfortunate that there isn't any way to resolve a officially induced error without going through the whole process again.
Yeah, well, life is not perfect, but we understand your concern. Thank you, note it. Recommendation on the application? Yes, Ms. McCall.
Well, kind of have no choice. We're going to have to approve it, right?
Well, no, you do have a choice, but I'd like to hear your recommendation and we'll discuss it.
No, my recommendation is to approve the application as set before us. It is an unfortunate error, and the differences are very minor. Difference of 0.05 for the garage projection and 0.03 for the front yard setback, as well as a proposed variance. Nothing has changed, everything is submitted. So the condition that staff is requesting is that the proposed garage additions and front covered porch be constructed in general accordance with the plans dated April 24th of 2017 as submitted. And I guess we
And I
don't need
guess,
the approval of the our 2-year expiry
Yes.
because it is already built and
Okay, thank you. Yes, she just said that. Yeah, she said to include it.
no, I said not to because it's already,
Well, no, building permit's required,
okay.
yeah.
Okay, so then
So we'll
the
need that condition.
approval will expire within 2 years from date of the decision if the proposed amendment has not proceeded and a building permit not issued.
Correct, okay, thank you. Discussion, recommendation? See none, all those in support? No one opposed, sir, your application is being approved again.
Thank you.
Thank you. Okay, application CAB 074-2017. This is an item that was deferred from April 25, 2017 at 454 Maple Avenue.
Yes, good afternoon, good evening. Arlene Beaumont appearing for Bill Outred and Associates. We are the agents for the owner of 454 Maple. As you mentioned, it is a deferred application. Since it was deferred in April, we have worked quite a bit with planning to revise the proposal. It's a little bit different than what you saw back in April. We've moved in this second floor portion away from the side lot line. The size of the home has been reduced, and now there's only one portion of the home remaining. That this section in the center is the only portion that requires a variance for height.
Right.
We now have positive planning comments, and I think that the proposal we've come up with has made a lot of compromise and is much more consistent with the area.
Perfect, so deferral was helpful.
Yes, it was.
Okay, so is anyone here that has an interest in application CAVA 74-2017 at 454 Maple Avenue? All right, we'll take this man to committee. Thank you very much. Members, who would you like to move a recommendation? We do have a letter or an email. Yes. The owners of 466 Anthony Drive object to the variances, so we should note that for the record. Okay, thank you. Who would like to move a recommendation? Thank you, Mr. Charlebois.
Mr. Chairman, having conducted my site visit, read the staff report, and listened to the quick presentation here, noting that there's no one here in attendance objecting or supporting, but also taking into account one particular email here from the owner of 466 Anthony Drive, and having read their comments, I believe that most of their concerns will be addressed in the building permit stage of things. So I find that this particular application does meet the 4 tests under the Planning Act. I make a recommendation that this be approved, subject to the condition that the proposed dwelling be constructed in general accordance with the plans dated June 19th, 2017 is submitted, and further subject to the condition that this approval will expire 2 years from the date of this decision if the proposed development does not proceed or a building permit is not issued.
Okay, thank you. Discussion, recommendation? Seeing none, all those in support of the recommendation with the 2 conditions? No one opposed, the application has been approved. Thank you. Okay, we'll deal with our last application, CAV A 86-2017 at 106 Georgian Drive.
Hi, Tammy and Ben Smith. We're at 106 Georgian Drive. We're the homeowners.
Okay, and there's, again, just for the record, no one's here left anyways for application, for any application, CAVA 86-2017, 106 Georgian Drive. Members have been in your hand. Would you wish a presentation? This is a matter that was deferred from our earlier agenda. We do have a petition signed, I guess. In support. And we do have a letter of concern expressed by the Halton Standard Condominium Corporation, number 449. So, would you wish a presentation, or do you have any areas of clarification? Anything you wish to add to the application?
No, we've submitted the completed shadow study. We
Yes.
submitted the letter that we actually put on all those condo townhomes door,
Yes.
opening the floor to discussion, and no one has talked to us. And we did call the Property Development Committee 3 times, left messages, and no one got back to us.
That's really unfortunate, you know, that's
So
really.
we've tried, right, to
You've
reach
done
out.
your work. We hear you. Thank you very much for that. Members, you have any questions, any items? No, seeing none, we'll take this matter to committee then. Who would like to move a recommendation? Mr. Tulowski, thank you.
Thank you, Mr. Chair. I'll move the application be approved, finding that it meets the 4 tests of the Planning Act. The proposal in front of us, I would say, is very consistent with other redevelopments in this area. I would note the letter of objection from the Condominium Corporation, but Mr. Chair, in reviewing the issues that it raises in relation to where the condominium sits in relation to this property, I don't believe that they will be negatively impacted by the variance requested and the construction that follows. So with that, again, I'm going to move approval of the application, making it subject to development proceeding in general accordance with the drawings provided, and that a permit issue within 2 years.
Okay, discussion on recommendation to approve subject to those 2 conditions. Seeing none, all those in support? No one opposed, your application has been approved.
Thank you very much.
Members, we have no minutes. We need a recommendation to adjourn. Ms. McHale, she moved a recommendation to adjourn. All those in support? Okay, adjourned at 8:36. Thank you.